Hold on.
My person on the waiting room must have jumped out.
I know, he did an excellent job. I always knew that one of y'all came, we're going to have an interesting day. Because, you know, most tenants that have lawyers, they can't afford it. And y'all couldn't have a lot of cases. But, well, I always feel interesting. I had a case with one of the biggest law firms. I wonder if you picked a woman for the nurse.
We're up and running on the live. Let's let everybody know that.
Okay, just hold on. So one of the picked a woman for nursing home. And so the young female lawyer was and I said, if you read, and I cited a section that said this doesn't apply to education, medical facilities. And she hadn't read it. I said, so this doesn't fit. You may have a deal with it, maybe you breach of contract or something. I really, well, I really guessed it, and they appealed. Well, they made a motion for retrial, so I made a motion for retrial, and they're sitting with some possible willing cause. And I said, even if you were right, and this did the law said you can't have unconscionable provisions in this. And this thing, you've got maybe 40 the most unconscionable things I've ever read. And that may be a failing contract, whatever this is. So I ruled against it and appealed it. And of course they never sued, so it's just amazing how few lawyers do things unless you look at real estate. I had a bunch of landlords who just come every time and just said that to the landlords, which I was very pleased to see. Landlords understand this. And they're the ones that need to know what to do.
What's my name? Good evening. Good to see you. Yeah, you doing all right? How you working? It's not said, right? Yeah. I want to know if I say it. So good, man. Alright. Alright, I got you. I'm passing on. You know what? Okay, we're gonna sit right here and there.
Just a few housekeeping rules. The bathroom is located out the double doors, straight to the back. Just open the door, and the men's, I believe, is on the left-hand side, and the women's is straight to the back. Trash cans are on either side of the room. So I'm gonna wait a couple of more minutes, and then we're gonna just go ahead and get started.
It's been involved, I started in 2011. Did she have a different last name? Was she short? Yeah. Kelly, I'm sure she holler she. What about like
They have it right there.
Derek? I figured most people have been legitimately over 10. I figured most people. I can believe it. I can believe it. Okay, well, you gotta be like. I think it was really big. So. Okay. How is it now? I remember it was like, how, you know, because I heard that you know me and thinking about someone. I was like, I had, but I know there's a lot of turnover in the head, so I can't speak for others.
Can you all hear me? Oh, there it goes. Okay, good evening, everyone. My name again is Dominique Dawkins. I work for Spartanburg County Community Development. This is the joint city-county landlord tenant workshop. We thank you all for being here. We thank those who are also streaming with us online. The goal of this workshop was just to provide some educational understanding and knowledge to our community on the renters' rights as well as landlord rights, get to know some of the professionals and experts in those fields. We've got a great panel for you today, and I'd like to thank the city's team for being here, and some of our agencies who are here as well. And thank you all again for taking your time out this evening, this hot Tuesday, and being with us today. So we hope that you take some great key takeaways from this workshop, and at the end, we will be emailing a survey. We hope that you online, and we hope that you can just provide us with some valuable feedback, because we are hoping to make this a series in the fall. So, without further ado, I will go ahead and just do a brief intro of our panelists, and then we'll take a brief pause, and then do our introductions. They'll come up and do their presentations. So first we have attorney Randy Powell-Farr, who works for, as a managing attorney for Spartanburg Office of South Carolina Legal Services, which is a statewide law firm that provides free civil legal services to protect the rights and represent the interests of low-income South Carolinians. The Spartanburg office serves Spartanburg, Cherokee, and Union counties. Eviction defense and other tenant-focused cases have comprised a large amount of Ms. Farr's caseload since she joined SCLS in 2013. Some of her other practice areas include family law and public benefits law. She's a native of Lawrence County, South Carolina, and is a graduate of Clemson University with a bachelor's of history and the University of South Carolina School of Law.
Good evening, I'm Randy Lynn Farr, and I am here tonight just to go over some legal rights and responsibilities in the landlord-tenant relationship. While I typically represent tenants in my normal day-to-day practice of law, I have in the past owned rental property, and I've also feel that it's very important that landlords also understand the laws, because that's probably the best protection for landlords and tenants. Is for landlords to understand what their responsibilities are and how the eviction process and the laws work. So just an important note, as an attorney, I always have to have the disclaimer that me being here does not create an attorney-client relationship between any of y'all and me, or any of you in South Carolina Legal Services. I may not be able to answer specific questions or otherwise provide you with legal advice. And in dealing with a specific situation, you should not rely solely on the information presented tonight, but should obtain the advice of an attorney. So there are several laws that can apply to the landlord-tenant relationship. We have the state laws, and the majority of that is now in the South Carolina Residential Landlord-Tenant Act, and that's what I'm going to be primarily focused on today. And then also federal laws do apply sometimes if it's a federally or public housing. Both federal and South Carolina laws would apply. And in many situations, the federal statutes and regulations will give the tenant more rights and responsibilities than under South Carolina law alone. So the first step is, looking at whether or not there's a lease agreement. And so a lease agreement, a written lease, is not required in South Carolina under most situations. Oral and written rental agreements are valid. However, it's always best to have a written lease agreement to protect both the landlord and the tenant. And a written lease can clarify the amount of rent that's to be paid, where the rent's supposed to be paid, and how long the rental agreement is going to last. And it can also specify if the rental agreement is going to become a month-to-month rental agreement or tenancy at the end of the lease. So if there's not a written agreement, even without one, acceptance of rent by a landlord without any reservation and acceptance of possession of the property and payment of rent by the tenant will give the same effect as if it had been signed. And then in those situations, the frequency of the rental payments will determine the length of the lease agreement. So if tenancy is paid week to week, it would be a week-to-week tenancy. More commonly, it's going to be paid on the first of the month, and that would be a month-to-month tenancy. So there are some things that cannot be included in a lease agreement. A tenant's rights cannot be waived. You cannot authorize a person to confess judgment, transfer responsibility or liability of the landlord to the tenant, and any other terms that are considered unconscionable. If these provisions are in a lease agreement, there can be some stiff penalties for landlords who intentionally include those, so you want to be careful about doing anything that doesn't run afoul of these, or I believe Ms. Watson's going to talk, or Smith is going to talk about fair housing, so you want to make sure that you are aware of all of those laws as well. So there are responsibilities for both the landlord and the tenant in a landlord-tenant relationship. So a tenant both parties have a duty to act in good faith with each other and to comply with the terms of the lease agreement or laws. Tenants have the obligation to pay rent on time, and the landlord has the duty to turn over the property at the beginning of the lease or to take efforts if there's a holdover tenant to get them out of the property. Tenants are not allowed to change locks or unreasonably withhold access to the landlord, and The landlord cannot wrongfully exclude a tenant or refrain to provide essential services, and must return the security deposit. And we'll go through all of these a little bit more in depth. So the landlord has a duty to comply with building and housing codes that affect health and safety of the properties. All repairs and do whatever is reasonably needed to keep the premises in a fit and habitable condition. It doesn't have to be the Ritz, but it needs to be safe and clean. And if it's a multi-unit property, then that also applies to common areas. Those need to be kept safe and clean. Supply reasonable amounts of running water, hot water, and heat, meaning that they can be hooked up directly to the public utilities if that's how the property is set up. And also keep all electrical, gas, plumbing, sanitary heating, ventilation, air conditioning, and other facilities and appliances that are supplied in reasonably good and safe working condition. So while South Carolina does not recognize air conditioning as an essential service, I don't understand how that works, but heat's an essential service, air conditioning is not. However, if the air conditioning unit is there when the tenant moves in, along with any other appliances, then it's the landlord's responsibility to make sure that those appliances continue to work. So if there's a refrigerator or washer and dryer that's supplied when the tenant moves in as part of the lease or that's there, then if that breaks, the burden is on the landlord to repair that item. Tenants also have responsibilities as far as complying with rules from applicable housing and building codes, so they can't have infestations or anything like that. And the lease will normally govern who's responsible for pest control. To keep the unit reasonably safe, clean, refrain from disturbing other tenants, follow reasonable rules and regulations. So access is a big issue we see. Landlords and their agents can access the property without the tenant's consent in very limited circumstances. If there's an emergency at the property, they get a call from a duplex upstairs, downstairs, they get a call that there's water coming in and the tenant's out of town, and the landlord can get access to go in and see what's going on. Between 9 a.m. and 6 p.m. for regular services. This has to be in the rental agreement, and they have to announce their intention before entering the unit. Between 8 a.m. and 8 p.m. for services requested by the tenant. If there's a court order, in all other cases, the landlord must give at least 24 hours notice and may only enter the unit at reasonable times. Tenants cannot unreasonably withhold access, and landlords cannot abuse this right of access. So another big issue we see a lot of times in Spartanburg and in other counties that we serve is a failure to maintain property. Tenants, you cannot withhold rent in South Carolina. That's a common misconception. There are remedies available, but withholding rent is not a remedy that's widely available in South Carolina. Tenants need to give written notice to the landlord that specifically lists the problems. And I always tell clients the best practice is to send the notice by certified mail to wherever the rent is paid. It doesn't have to be sent by certified mail. Some judges will consider a text message writing, but it's always best if I still do the old-fashioned letter. The landlord then has 14 days to fix the problem, unless it materially affects health and safety. If it cannot be fixed within the 14 days, the landlord can begin the repairs within 14 days and finish within a reasonable time, and that is not considered a breach of the lease. If the repairs are not made or they cannot be made, in the notice, the tenant should outline his or her intent to terminate the lease if the repairs are not made. They also have the option of suing for actual damages and reasonable attorney's fees. That could include moving costs. That's something that tenants are going to have to front themselves up front and then seek reimbursement through the courts for. If the tenant would rather stay, there is a way to file a court action to require the landlord to make repairs. In my experience, that's oftentimes very hard to do as a practical matter. They can also seek actual damages. This could, in some situations, include diminished value of the property due to damages or the condition of the property. Tenants cannot terminate a lease or sue for damages if the issue that's needing repair was caused by the tenant, a member of their household, or a guest of the tenant. Essential services are sanitary, plumbing, and sewer, electricity, gas for its use for heat, hot water, or cooking, running water and reasonable amounts of hot water and heat. So there are a little more protections with essential services. The tenant must give the landlord reasonable notice. There's no 14 days in there. And after a reasonable time, services are not rendered. The tenant may obtain reasonable amounts of the required essential services during the time of the landlord's failure to provide these, and deduct the actual and reasonable cost of services from the rent. Or file a court case against the landlord for damages based on the change in the fair market value of the unit due to the missing essential services and for reasonable attorney's fees. The Landlord Tenant Act does not allow tenants to make repairs and deduct repair costs from the rent. So what this may look like is if the heat goes out and someone needs to go buy space heaters, or they need to go to a hotel for a few days, you need to keep your receipts and be very detailed in documenting that before you just assume you can go stay at the Marriott and ask the landlord for reimbursement. That's not what that means, and that's normally not how it's going to be applied in here. Failure to comply with the terms of the lease. So when the tenant doesn't comply with the terms of the lease, the landlord has very similar remedies. There's the same 14-day notice. So the landlord has to give written notice to the tenant that clearly outlines the behaviors or conditions that are a violation of their lease agreement, and states that the lease will end if the breach is not fixed or actions are not taken to fix the breach within the 14 days. If the tenant can fix the breach, or the breach cannot be fixed within 14 days, but they start it and make a good faith effort to complete it, then the lease remains in effect. The landlord at that time cannot pursue the eviction. So a common defense that I raise against landlords is a lack of notice. So a lot of times someone has an unauthorized pet or an unauthorized person, and they just get served with eviction papers that say breach of lease. Well, as a tenant's lawyer, one of my best defenses is lack of notice. They were not given written notice. It didn't specifically outline that, and it did not notify them of their opportunity to cure. And so that is typically a way to educate everybody about the situation and hopefully get the issue resolved before people end up on the street over something that they may or may not have known was even a violation of the lease.
That's the question. How long of a notice? How many days?
14. And we'll do questions at the end as well. So another common one, especially around this time of year and in general, is just a failure to pay rent. So the landlord must give a written notice that rent is past due. And in cases of non-payment of rent, the notice period is 5 days. The notice only has to be given once during the lease term, and one notice can be given in the lease as long as it is ambiguous language. There's actually language in the Landlord Tenant Act that if it's in the lease and I see it and it's a non-payment of rent case, typically there's not going to be a defense for that other than proving that you have the money orders and you did tender rent and there's something else going on. The tenant must pay the rent within 5 days of receiving the notice. If the rent is not paid within 5 days, the landlord can then start the eviction proceedings. Unlawful ouster. This is where landlords can get into a lot of trouble because there are no self-help evictions in South Carolina. If the landlord unlawfully removes or locks out a tenant or willfully stops or reduces essential services to the unit, then that is considered an unlawful ouster under South Carolina law. And the tenant has the ability to file suit to either recover possession or terminate the rental agreement and receive a security deposit refund and recover the greater of 3 months' rent or twice the actual damages plus reasonable attorney's fees. So, what happens when it's time to part ways? So everything normally comes to an end. My dad's parents rented a house. He grew up in it in Honeypath, so they were renters his entire life. And they moved there when he was probably early elementary school, and they moved out when my grandmother went into an assisted living facility about 8 or 10 years ago. So this was our family home. It was rental property. But at the end of the day, we had to move on. So notice at the end of the lease term, it's going to be governed by the procedures in a lease. A month-to-month tenancy, either party can terminate with 30 days written notice. There are always some best practices that I advise people normally after things have gone wrong, but I like to do it before they get there. So at move-in, if possible, it's a great opportunity to get to know the landlord and tenant, get to know each other. If you can do a walkthrough together, make notes of any damages, note any requested repairs at the time of move-in, and take photos of the property before any of the tenant's property is moved into the unit. And that protects both the landlord and the tenant, because it allows the tenant to show that there were gaps in the flooring when they moved in and they didn't do that, moving their couch on the floor. And it allows the landlord to show that there wasn't a gouge in the linoleum and, the kitchen tables what did that. And then at move out, if possible, also do a walkthrough together. Sometimes relationships sour and that's not possible, but when possible, it is advisable. Make notes of any damages and take photos of the property once all the tenant's personal items are removed. And if the tenant pays for carpet cleaning as part of the move-out conditions or other things that are outlined in move-out expectations, then they should keep copies of those receipts and be able to provide them to the landlord in case they're charged for that later. So the return of the security deposit. Security deposits are not required to be returned until 30 days after the tenant has vacated the property or has made a demand for the security deposit. So a tenant needs to remove all personal belongings, turn in keys, and personal items would include any trash or debris in the unit. Leave the unit in a reasonably clean manner and follow any move-out instructions that are in the lease agreement or other rules and regulations. Request security deposit refunds in writing at the time of move-out and provide a forwarding address to the landlord to send the deposit or an itemized accounting of expenses. The landlord has the duty to refund any property or money that's held as security, minus any amounts that need to be withheld for unpaid rent and damages that are above normal wear and tear. So normal wear and tear is not included. So if someone lives there 5 years, there should be an expectation that they've walked on the carpet's not going to look like it did 5 years ago when you installed it. Now, if they've lived there for a year and there's crayon scribbled on the carpet, that's a different situation. But normal wear and tear is normally not taken into account. Along with this amount, the landlord must send an itemized written notice to the tenant within 30 days after the termination of the tenancy and delivery of possession. And the notice must be sent to the forwarding address provided by the tenant. If there's no forwarding address, then you would send it to the last known address, which is your property address. If the landlord improperly withholds a security deposit, the tenant can sue for 3 times the amount of the wrongfully withheld security deposit and any prepaid rent with reasonable attorney's fees. And then here are some legal resources. As they said, I'm with South Carolina Legal Services, so we provide free legal representation to low-income clients. We do handle a lot of housing cases, both evictions, some other landlord tenant cases, and foreclosure cases. And we also handle family law, education law, public benefits, which includes Social Security cessation cases, SNAP benefit denials and appeals, those types of cases. We also handle unemployment and a wide variety. I have our general brochure at the back of the room, along with some of our landlord tenant law questions. And the number on the screen is our statewide telephone and intake service, and that is the number you would call to apply for services. If you are needing representation and you are not qualified for our services, then you would be able to contact the lawyer referral service to the South Carolina Bar.
Thank you, Attorney Farr, for your presentation. Any questions that audience may have. We are asking to reserve them for our question and answer panel. And you'll see a mic in the back for you all just to be able to ask your questions, so also our virtual audience can hear you as well. So our next presenter is Attorney Crystal Smith. And Attorney Smith is the founder and owner of K Laws LLC, a real estate and family law and estate planning law firm located in the heart of downtown Spartanburg. She is the owner of KWS Properties of Spartanburg LLC, a real estate investment company. She started her journey in real estate by working at a real estate closing law firm as a licensed real estate agent while pursuing her Bachelor of Arts degree at Unlawful Ouster. She attained her degree at Unlawful Ouster and earned her Juris Doctorate degree from Western Michigan University, Thomas M. Cooley Law School. She is licensed to practice in South Carolina and Michigan. Attorney Smith has served as managing attorney at South Carolina Legal Services in Spartanburg and Rock Hill. And as a sole legal aid attorney, she devoted her legal career to representing low-income families, victims of domestic violence, and senior citizens in civil matters such as divorces, custody disputes, adoptions, as well as defending evictions, foreclosures, and other property disputes. She has participated in various legal clinics and speaking presentations on issues such as landlord tenant rights, heirs property issues, and the real estate loan closing process. She serves on the executive board of the Spartanburg NAACP and on the South Carolina Bar House of Delegates for the 7th Circuit. In her spare time, she enjoys spending time with her family and friends.
Good evening. How y'all doing? Alright, so I'm just curious who we have in the audience. I know we have people online, but I'm curious, by a show of hands, how many people are landlords? It's okay, be proud about it. I'm a landlord too. Okay. And how many tenants do we have? Okay. I just like to know who we're talking to. I see some real estate agents, some other people in the community, familiar faces, but I wanted to kind of make sure that we talk about things that were relevant to people who were here. So thank you all for coming. I have to say I'm honored to be a part of this esteemed panel. I don't know if you caught it, but, you know, Attorney Farr and I worked for about 7 years together, defending landlord tenant evictions in front of Judge Cassidy over here. So it's kind of it's such a good feeling to be in the middle of them two. So with that being said, there's a wealth of information here, so I'm just happy to be a part of it. So I have been given the task to talk to you all about fair housing laws in South Carolina, and given a short amount of time to do that. So I'm going to try, can you hear me okay? I'll move around, okay. All right, so what I want to do is try to keep it simple, give you the basic information so you'll be aware of what to look for and where to go if you see an issue, okay? So, in a nutshell, you might know this, but maybe you don't. It is against the law, this is the South Carolina law as well as federal laws, to discriminate against a person regarding housing, and we'll unpack that in a second, on the basis of race, color, religion, sex, also gender, also known as gender, national origin, physical or mental handicap, or familial status. And that's usually the interesting one because that's pertaining to individuals with families or small children or pregnant women or that kind of thing. So housing. I'm supposed to talk about landlord tenant, but I would be remiss if we didn't include if you were buying a house. Those people who are renting may aspire one day to buy a house, so I think we should talk about both, and it relates to what is against the law. So you can't discriminate. We're gonna unpack that a little bit in a few minutes against those. So that's important to know. Those are what we call protected classes. So if there's some type of discrimination or you feel like you're being treated differently, you know, as it relates to renting a piece of property or, you know, trying to buy a house, working with a real estate agent, working with a mortgage company to get a loan to buy a house, on those bases, then that might be a violation of our fair housing laws here in South Carolina, as well as violation of the federal laws that we have. So, and I also put here, this applies to, like I just said, the sale of a property, rental property, and financing. So for all the landlords in the room, you are not exempt from this. And I say this, I'm a landlord, so you have to, you know, follow these rules as well. You're not exempt by that, even if you're like a private landlord. So I know you might be thinking, well, I don't rent to, you know, I don't do public housing, I don't do Section 8 housing, so I can do what I want. Well, you can kind of do that, but you can't do that. You can't discriminate on those bases. I don't care who you are. Okay. All right. Now, I'm not fussing, but I will tell you this. I've done, you know, civil defense, defending landlord tenant evictions for a long time, so I'm so hard on my landlords. I represent landlords now, like I said, I am one, and I'm very hard on, like, we gotta do this the right way. If you're gonna rent a property, you have to learn what you have to do, and do it the right way. And that's what, you know, I'm very passionate about that. Okay. So, what I want to do is just talk through some examples, because we don't have a lot of time to unpack all of this. So let's talk about what are some examples of housing discrimination. Are you ready to play?
Yes.
Okay. Now, the following example is not, okay, this is a true or false question, is not a form of discrimination. So let's talk through it. A bank refuses to lend money to a house buyer who wants to purchase a house in a minority neighborhood. So minorities primarily live in this neighborhood, and the bank refuses to give this person money because of that. Is that, and I said that's not a form of discrimination, is that true or false? Somebody said true? I can't even call them out. Let's see. False. So, should we go back? We need to go back? Okay. We need to go back? Okay, a bank, so so it's false, that means it is a form of discrimination. Well, make sure we got that. Okay, so a bank, let me put it to you this way, in the next slide. Let's see. Did you miss it? We're gonna go back. So it is against the law for a bank to deny a home loan because the house is in a minority neighborhood. So here's the thing about discrimination. It is often very subtle. I wish that it would be that blatant. It normally isn't. It's almost like you gotta, this doesn't feel right. That's usually how it ends up. So I doubt that anybody would ever have a bank outright say, we're not gonna give you money because we don't like the neighborhood that you're buying from. What you'll probably see is something else that maybe doesn't sound right and it seems fishy. Maybe they'll say, oh, the appraisal was too low, or, you know, and then you start to think. And so I've had that conversation a few times recently, like I think that the bank is trying to come up with other reasons why they don't want, you know, me to have this house, or whatever the case may be. If it's an appraisal, I suggest you get another appraisal. You pay for it anyway. So, you know, do some other things to try to kind of dig into that sometimes, because of the issue with a lot of discrimination is that this is 2022. People are not going to just outright tell you. So the issue is it's very subtle. So I use this to say, I gave this example as an example of redlining. So I want to give you an example that actually happened to me and my husband. When we were engaged, we were looking at buying a house, you know, or, you know, the house, the picket fence, and all this stuff. So we were looking to buy a house, and we were in a subdivision where they had a real estate agent that were, you know how to do subdivisions are, they have a real estate agent sitting on site. So we went without a realtor, which you should never do, always get a realtor, okay? Don't just talk to the people that work at the subdivision. It was a hard lesson. See what happens to me, you know, like I'm giving you what happens in my case. So we go to the subdivision, and we, you know, want to see the house. We want to, you know, look at, this subdivision, we like it. And the realtor she literally took us out of the neighborhood and took us to another neighborhood that was obviously lower in price than the neighborhood that we intentionally drove to. So you see, she didn't say, I don't think you can afford it for whatever reason. She didn't directly say that, but it didn't make sense if we intentionally drove to this neighborhood. Why would you drive us to a different? Like, I think you would like this better. And the irony was, my husband already had a house in the neighborhood that was similar to that price point. So we were thinking, no, this is what we came for. Now, I should have probably reported that, but I didn't. And so I just want to use that as an example of things can be very subtle. That was not her job to make that assessment. And of course, she asked me later, well, what did you do? I'm a lawyer. Is your attitude changed? You know, but I'm not working with you now, you know. Anyway, so that's redlining. So I think I gave the official definition of redlining in my presentation. It's really lease. Redlining is a systematic denial of various services to residents of a specific, often racially associated neighborhoods or communities, either directly or through the selective raising the prices. And so if you Google redlining, you'll see tons of examples of that. I can't stress to you enough that it's so subtle that you have to be just, I hope what you get from my segment of the presentation today is just have this little ding, something's not sounding right, maybe you need to ask people about it if you hear anything like that. So, next example, not trying to put you up, so let's go through this. The following is, and this is a true or false question, the following example is a form of discrimination. A real estate agent insists on selling homes in one neighborhood to minority home buyers despite their varying levels of income.
False.
True. Good job. I wish I had something to give you. I heard you say he was real confident. You said true. I saw you. Okay, so that is a form of steering. A real estate agent cannot insist on selling homes in one neighborhood to minority home buyers despite the varying levels of income. Does that sound familiar? You know, then you see where I put that in here? You can't do that. That's illegal. So that real estate agent, shame on that real estate agent. I could have reported her, but I did not. Now, so the steering, we kind of talked through it. It's this illegal practice of directing a prospective home buyer, such as myself, to or away from a neighborhood based on the presence or absence of, protected class. So I'm not, again, intention is hard to prove. So I'm not going to say she just assumed I didn't have the money because of the color of my skin. I'm not going to say that. But I will say that there was no basis for her to just take that and move us, drive us out of the neighborhood that we physically drove into to look at. So that's something to please be aware of. Now, I have one more. Going back to Landlord Tenant world. The following is a form of discrimination. True or false? I love the confidence. A landlord evicts a tenant because he or she refuses the sexual advances of the landlord. Is that a form of discrimination? Sure. Can't do that, landlords. Okay? You would think that, you think they know that, but you'd be surprised. All right. So, the big takeaway that I want, because I don't have much time. Do I have some time? Okay. Please help me with that, because I'll get on a rant about something. The big takeaway I want you to have about housing discrimination is if you see it and you think something's happening, what do you do about it? You can report it. The cool thing that we have here in South Carolina is we have the South Carolina Human Affairs Commission. And so that's located down in Columbia, but they have a team of investigators. They will go all throughout the state of South Carolina and investigate things as it relates to what you think. So you don't have to do the digging. You don't have to do the investigation on your own. If you think something's not right, you make a report, and I provided their address, their phone number, their website, their email address. Just shoot an email and say, hey, this happened to me. I don't know if that was right, what are my options? So they will investigate. Now, the kicker is they don't have a whole team of lawyers that works at the South Carolina Human Affairs Commission, but they do have enough where if they investigate and they determine that there's a potential violation of state law, then they will send you a letter and tell you that, which is kind of like a golden ticket letter, if you will, where you can go to a lawyer and say, hey, this happened to me, they think that I have a case, so, would you represent me? And that way you'll know, instead of going to the lawyer. And, us lawyers, we don't have time to investigate things like that. I mean, I think in this very room, I've been in a presentation with the Housing Affairs, the South Carolina Human Affairs Commission, where they mentioned that they will have people go to apartment complexes undercover. If you're thinking like, I was denied an application at this particular apartment complex, there was no real basis. I have good credit, I have work history, there was no reason why I should have been denied. I think it might be because of my gender or my race, whatever we talked about of the protected classes. They will have people call and apply for housing and see if they get the same experience. So I just want to stress to you that if you see it, point it out, call, get it investigated, because that's the only way that we're going to have those things like what happened to me, addressed, and people know that they're not to do that. Okay. So, how much time do I have? Okay. All right. So here's the one thing I will say also about fair housing. It's not like a fair housing law, but if I get a microphone, I always bring it up. So, because I'm done with my presentation. So here we go with this. I do that to stay on track. So that's my contact information. So let me just explain that briefly. I do landlord tenant work. I represent landlords now. I used to defend tenants. I represent landlords. I can help you talk through lease agreements. You want to get somebody evicted, you want to evict somebody, you want to talk to me about it, I'm happy to do that. My email, my website, my phone number is there. So let me tell you about something, and my ladies in the room know what I'm going to talk about because they've been in a couple presentations. I want to share something that always happens, and it's just like the bane of my existence, and I think I might get some nods on this. What we call those land contracts? Buy, sell, what is the, land, it's so many names, shoot them out.
Contract for deed.
Thank you. Contract for deed, land, what is it, Judge, you've probably seen some other ones in your courtroom too a few times. Well, anyway, you know these contracts where you're renting a piece of property, maybe you talk to the owners about buying the property. I completely get it. You want to buy property, we all want to be homeowners. But I want you to do it the right way. I can't tell you how many times I have seen it, they have seen it, where you enter into these agreements to buy a piece of property that you've been renting, and the agreement always goes sideways quickly. And a lot of the reasons why is because, the title to the property isn't right. You don't do the necessary steps that you would have if you were to go and buy the property. So you get a real estate agent, you do your title searches, you do your inspections, and all these things that you do when you're normally buying a piece of property is almost circumvented when you do it that way. I have seen so many people come to my office in tears because they have signed these really bad agreements. So I'm just stressing that to me it fits into fair housing because I believe that is somewhat, what's the word I'm looking for, Lynn?
Unfair trade practice.
It's very deceptive. People are agreeing to buy properties at an interest rate you wouldn't believe, and they didn't talk to a lawyer. They signed these agreements, and a lot of times the owner might have a mortgage and they're not paying the mortgage, and so now all of a sudden you're buying this house, you think you are, and the house is up for, foreclosure, and then, you stop making the payments. It's a mess. And so I'm stressing when I have an audience to don't do that. If someone is saying, if you got with a realtor or a bank and they're telling you, your credit score could be a little better, maybe you need to have a little more work history, just do that. Listen to what they're saying because you're losing a lot of the protections. And I mention it a lot because the law in South Carolina doesn't give us a lot of protections with these bad agreements. So if you get into one and you want me to get you out, I don't have a lot of law to get you out of these agreements. So I just want to make sure that you be mindful of these documents. Like if you're going to sign a lease, rent the property. but don't do the whole convoluted lease today, I'm buying it tomorrow, this whole thing. And if you do, you don't have to call me, but call a lawyer before you sign these documents if you hear anything I say today. Now, that's all I have to say. I can go on. Okay, I'm done. All right, thank you.
Thank you, Attorney Smith, for your insightful presentation. So again, our goal today or tonight is just for you all to learn some new information. If you already know the information, we're hoping that this is a refresher for you. Take this information back to your communities or your neighborhoods, your family members, friends that you know who rent or are landlords or hopefully future home buyers. So we're just hoping that you just gain some new knowledge, and with that, I'm going to jump right into our last esteemed panelist today, and that is Judge James Paisley. Judge Paisley graduated from Spartanburg High School, Wofford College, and the USC Law School with honors. He became the youngest Spartanburg County magistrate ever appointed when he was first appointed, and retired as the longest ever serving Spartanburg County magistrate after nearly half a century. He supervised all the departments of the court and served as a chief magistrate. Judge Paisley established the first upstate domestic violence court and fully computerized the magistrate system. The Spartanburg County Bar Association awarded him their highest honor, the Cloud Taylor Award, in 2016. Judge Paisley was also awarded the Order of the Palmetto, which is the highest civilian award in the state, in 2018 by the governor. And so with that, I'm going to ask Judge Paisley.
Thank you very much. My esteemed associates have appeared before me a number of times, as they said, and I always knew that when they came, it was going to be an interesting case, because they are well prepared, as you've heard, knowledgeable in this law. But this law has only been in existence for about 35 years. When I started, this law didn't exist. And the reason that it's important to know is that when this state was established as a colony in 1670, we were established from England, and only wealthy white men could own land. And it was many, many years before women or minorities could own land. And so, very seldom were women or minorities or average white people able to be landlords. They were tenants. And so those same people, those same wealthy people, wealthy white men, were the ones elected to make the laws. And so there were no laws protecting tenants. Over the years, gradually a few laws came into existence, but not until 1985 was this South Carolina Landlord Tenant Act passed. And so I started out in the beginning dealing with these cases, and there was very seldom any defenses that tenants would have an opportunity to present. And that was very sad, obviously, because, you know, normal contract, each party has some rights and responsibilities, but in the landlord-tenant law, up until 1985, the tenants had very little law. Very little law. But now my fellow lawyers have practiced law during the time when this law was in existence, so they haven't seen some of the difficulties that existed before, and they presented to you some of the valuable protections that exist now for both landlords and for tenants to make their responsibilities more important. And I will say to you, if you are a landlord,
You need to learn this law. It is 25 pages long. A long, long law, but if you don't know it, there are lots of problems that exist, and I want to just talk about a few of them that exist. One is the fact that landlords must provide essential services, and that's been explained as heat, running water, and electricity. And many times in my court, in the 100-degree temperature in the summer, people will come in and say, we have no air conditioning. Sadly, air conditioning is not an essential service. And really, someone needs to talk to the General Assembly and add this as an essential service, because it's almost hard for me to imagine living in an apartment or a house without air conditioning. My wife and I, when I was in law school, we lived in an upstairs apartment. We had an air conditioning unit in our bedroom, and that was the only one. And it was 100 degrees in Columbia, and that was a difficult time. And now it's 100 degrees in Spartanburg in the summer. It's very difficult. So those are some things that maybe need to be talked to the General Assembly about changing to help tenants have a more livable environment here. We're going to talk a little bit about some other things that landlords really need to know, and I'm shocked sometimes when they came in my court that they didn't know. And I unfortunately don't recognize a single landlord in here today, but I've been retired for about 3 years. But we have our court on Friday afternoon, Central Court, Spartanburg, Friday morning, 9 o'clock. And we would have somewhere between 250 to 300 cases. Now that sounds like we could never finish those. But the law says that the landlord starts the action by serving a notice, written notice on the tenant, specifying the grounds they're seeking for an eviction. Usually it's non-payment of rent, but it could be some other grounds. But it's a sworn affidavit served on the tenant. The tenant then has a right to show, through what we call a rule to show cause, why they should not be evicted. But seldom ever do the tenants appear. So when the tenants don't appear, they present no evidence, so the landlord automatically gets their eviction. Of course, occasionally when lawyers come and represent them, they present defenses, and some tenants present, or at least attempt to present defenses themselves, but we'd only have probably 10 or 15% of the cases where there would be people appear to present defenses. So it was always sad to see that few people understood this, and understood that they might have had some rights if they had talked to a lawyer, if they had looked up this law a little bit themselves. And I realize the average person will have a hard time understanding this 25-page law. But some lawyers, and you've got a couple here, excellent lawyers who do understand that. But there are not many that do. I taught at Congress College the paralegal program for several years. And I would ask the paralegals or assistants to lawyers, go back to your lawyer and ask them if they ever heard of the South Carolina Residential Landlord Tenant Act. And a few of them come back and say, yeah, we've heard of it, but they don't know anything about it. And of course they don't, unless they work in real estate law, unless they represent landlords, generally speaking, or sometimes tenants. They don't do it. I had a case once, and I'm going to tell you that this law doesn't apply to every arrangement where people live in someone else's house. For example, there's an exception to this. Okay, this does not apply to a fraternity house, a hotel, a vacation home, a hospital, medical facility, or a nursing home. I had a case once when one of the biggest law firms in Greenville came by, and they wanted to evict a lady from a nursing home. And so I asked the attorney, have you not read this section that says that you can't do that? This is not under the South Carolina Residential Landlord Tenant Act. And so you can't evict someone from that. So I denied the right. That was a young attorney from the law firm. So the law firm filed a motion for a new trial, which we always give them opportunity to be heard. So they sent one of the big, powerful lawyers over. And I asked him if he'd ever read that before. before. You know, okay, well, but this is, I said, well, even if you were right, Judge, you're not, but even if you were right, the law says, as you've already been told, that you cannot have unconscionable provisions in a Landlord Tenant Act. What is that? That means a term that shocks the conscience of the court. And in this contract for the nursing home, there was at least 30 clauses that would shock the average person. In the Residential Landlord Tenant Act, the landlord cannot force the tenant to give up any of their rights under this law. And in this contract that they had, they were giving up everything. I'm giving all sorts of kind of things, and it was just shocking. So anyway, I ruled against them, and they appealed, and I was upheld on the appeal. Those are the types of things that even good lawyers sometimes don't understand. But this is a very important law because it protects tenants from things that were happening before and should be happening today. And it also protects the landlords because they have rights too. The tenants flush disposable diapers down the toilets, which often happens. The tenant is responsible for that. And if they do that, and the landlord has to get a plumber, the tenant has to pay for that. That is either that or they will be evicted. If the tenant not supposed to have pets in their house or supposed to pay a fee for pets and they don't do it, those are grounds that a landlord has the right to evict for. And if the tenant does intentional damage to the property or extreme damage to the property and does not repair it, then the landlord has a right to evict for those grounds also. Now I want to talk about one of the things that I found that was very shocking to me. The landlord can allow, can ask for, and they always do, a security deposit, which is the amount of money to pay for unpaid rent. You do have to evict the tenant, or for any damage beyond normal wear and tear on the premises. And they have the obligation, the landlord has the obligation, to send the tenant a notice within 30 days of them leaving the property, telling them if they're going to use any of that money and for what purpose. Assuming that the tenant gives them their mailing address. If they don't give them the mailing address, that should be sent to the address they were renting at. But if the landlord fails to do that, then the tenant can bring an action for 3 times the amount of the money that was spent that was not supposed to be done. And I am shocked to learn from many landlords that they don't know that, and they don't follow that procedure, and I've awarded tenants several times the money because they fail to do that. Plus attorney's fees, by the way, for that type of action. Now, there's also some things, and we were told earlier that some federal laws apply, and there are some federal laws that apply here, and some that are very important. One is that you cannot evict a member of the military or household member if that member of the military is in active duty. And that's a very important protection that exists for the families of and for members of the military. So those are essentially the items that I'd like to cover for you. There's no possible way that in a few minutes you can cover this entire law, but I'll strongly recommend to you, the Public Library has this statute, has some books on it, and it begins, if you want to look it up yourself, it's section 27-40-10 of the South Carolina Code of Laws, and you can find that on the General Assembly's website. Go to the General Assembly's website and look for statutes, and you can find this and read it if you like, or you can check it at the library for some of the sources that are there. I also want to tell you that I'm very proud to have served in Spartanburg County's Magistrate Court. The South Carolina Summary Court Judges Association recognizes our county as the best magistrate court in the state. We have more lawyer magistrates than any other county in the state. We have excellent district judges across the state, and I'm proud to have helped train some of those, and we have an excellent group of judges at the courthouse. And a good friend of mine Judge Kerry Gilroy, who's now the Associate Chief Justice, the Chief Magistrate, who also is very knowledgeable in this area of landlord tenant law. So if you have questions, our magistrates will be able to try and answer any that we can for you and put you in the right direction if you need some help on these matters. Also, I'm proud to have written a book about the magistrate court history here, and hopefully some of you might be interested in it. It's available at the Hub City Bookstore and also on Amazon, called the Spartanburg People's Court. And I think if you're interested at all in knowing what's going to happen to you if you go into that court, if you have a traffic case, if you have a landlord tenant matter, or any other things, you just want to know what to expect and want to know about some of the judges, like Ellen Hines Smith, who was my mentor, you might find some interesting information there. So thank you very much.
Thank you, Judge Paisley. So now we're going to move right into our question Q&A section. Are there any questions to start off before I'll ask a question, but I want to ask the audience first if you all have any questions. Do you have a question? Do you mind coming to the mic here?
Can the landlord make the deposit non-refundable and put that in the tenant agreement? Or if it's in the tenant agreement and the tenant still signs it, is that a valid?
I'm not exactly sure I understand your question. Even if it's in there, it says in the agreement that the money will be refunded within 30 days of the end of the tenancy. That will not cover. The landlord will still have to send that 30-day notice specifying if they're going to take any of that money, why it was taken. So even if it's written in there, they've got to follow up with that procedure.
If they put in the agreement that the deposit is non-refundable.
You can't do that. That would be an unconscionable provision.
Thank you.
Good evening. You just had the eviction process up, and I was curious, when someone gets an eviction notice, does that go on their credit report?
Generally speaking, yes, if people know about it. Let me one thing I forgot to do a little bit about was really talk a little bit about evictions. As was told to you, for a landlord to evict, he's got to give the tenant a 5-day notice of the violation. That can be written into the contract in bold language into the contract, and then it will not have to serve you with additional notice. If it's not written into the contract, they have to serve you at least one time with a 5-day notice before they can start an eviction. If they serve you one time and it's settled, and then months later, still you do it again to relate with the money, they don't have to serve you the 5-day notice again. So they serve the 5-day notice on the tenant, and then on day 6, if the tenant hasn't paid it or hasn't been settled, they come to the court. The court then would set up a date for the hearing I just told you, which is the rule of show cause hearing, notifying the tenant to be there and show cause, if any, that why they should not be evicted from the premises. And then those hearings are held, and as I've said, many tenants never come. And those that do, then the court will decide whether or not they have a valid defense to the eviction.
I do just want to clarify, the process for the eviction hearings have changed due to COVID, so I'm not sure if Judge Paisley is aware of this, but at the main magistrate court, because of the volume of cases, tenants, once you're served with the notice, must request a hearing now. In years past, they would be served with a summons to appear in court. but now the tenant needs to request a hearing within 10 days of the date of service. And that did cause some problems for people who had had a similar experience in the past, and we're just expecting to have a court date. So that is now the requirement that you contact the number on the rule to vacate that you receive and request the hearing.
Do you know who changed that law? Because I don't agree with that. There's an absolute right to a hearing for rule to show cause. Absolute right. The tenant does not have to ask for it. I'm telling you. Now, I agree. I've been retired for 3 years, and I have not. I follow the changes in the state law, and I haven't seen that in the state law. Now, I don't know who made that ruling here, but I think tenants have an absolute right to that hearing. Absolute right to that hearing.
I'm not sure about that. I'm just the messenger, Judge Pasley.
I'm just telling you that unless there's been some change in state law, which I haven't seen, and there may have been, the tenants have an absolute right to that hearing.
I have a question like that. If you have rights, like you're saying, you have these rights, and you're not given these rights, I mean, what?
Well, that's what my argument is.
You know, because it's not a state law, and it's someone here locally just coming up with these laws. I mean, what do you do as a tenant? What would a tenant to do?
Well, I was
your rights are being violated.
Any tenant that gets served with the rules, gets served with the 5-day notice, ask for that hearing, unless you settle it before you do the thing.
But they just coming up with.
I agree that I have not had any dealings with changing any procedures, but as far as I know, it's still state law for a tenant to have that right.
I would add to that by saying what not to do is not do anything. So I think what you want to focus on is if you get any type of court papers. I know that, I know you probably get that, but we've seen a lot of people who do nothing. So don't do nothing. If you at least call, I don't want to give you more cases, but you can call South Carolina Legal Services. There's a civil legal aid for the state of South Carolina if it's a person who has no, means to talk to a lawyer or pay for a consultation or whatever the case may be. So there are options to do that. Talk to an attorney, go to the courthouse. I mean, because a lot of people will just kind of stick their head in the sand and think that it'll be better, and you don't want to do that. Ask the questions,
Because what we're seeing happen, especially at the height of the COVID situation, was that people were getting served with notices who may have been used to having these hearings preset. And Spartanburg was the rarity based on Cherokee and Union. They've always required tenants to request their hearing. But what we're seeing is people would come to us once they've gotten the writ of ejectment, which is basically what I always explain to people is the permission slip for the landlord to come in and set you out. Generally, that's going to be on the Thursday morning after your eviction hearing in the main courthouse at Spartanburg.
The CARES Act, is that still in effect?
COVID cares? Yes, we are still providing funding through COVID cares Act, yes.
There is still funding available. The eviction protections have sunset for that, with the exception, I believe, the provision that 30-day notices in federally subsidized properties may still be required, but I would have to double check that. But as far as the actual eviction protections, those have expired. There are still some additional forms, I believe, that some of the courts are requiring landlords to file.
Any other questions?
My name is Tamara. Can a landlord go up on your rent before your lease is up?
No.
Thank you.
Yes, I have an ongoing dispute about plumbing. He says I'm responsible for the plumbing, and I'm trying to prevent from going to court about it after this is my lease is up and all of that, how do I do that?
Let me understand this, you already have a plumbing problem?
No, sir, it's been fixed, but he's trying to charge me for it. And
Why is he trying, what does he say that you caused it?
that I owe for,
Well,
for the
now, the landlord can raise the rent at the end of your term.
Yes, sir.
And he can use that as a grounds for it, I guess, because we don't have any control over other, as long as it's not an excessive amount. The landlord and you can, renegotiate the thing after the lease expires. And you don't have to, stay if you don't want to, but it's just a new contract then. But he could not charge you for that during the term of your lease, but he could increase it once the lease expires, and so unfortunately, yes, that's true. I thought you might mean that you had a problem and you wouldn't fix it now, because that is, council told you give them 14 days notice, and they've got to take action on that. And if they don't, then you have grounds to end the relationship yourself.
Wait, one second, just to make sure. So the reason why he wants you to pay for the plumbing is because he thinks it's your fault? Is that the issue?
No, ma'am. It says I'm responsible for the opening of laboratories, kitchen, and all of that. It says I'm responsible for it. I have the letter. I'm sorry I don't have it with me, but.
That's okay. Well, I think it might be a lot more to this conversation that you would need to unpack, whether it's with me, Attorney Farr, or another attorney, but I think you need to talk to an attorney.
Okay.
So we can, because there's a lot of general rules, but without knowing all the specifics, I don't think we can properly advise you as to whether or not he was correct on that. Something doesn't sound right. I would like to know more about that.
Okay.
Okay.
My question is how many times can a landlord go on your rent a year?
Oh, wait a minute. Okay, well, generally speaking, your landlord cannot increase your rent while you're under a lease term. So if you sign a lease agreement, usually leases are a year, sometimes I've seen 6 months. So during that lease term, the landlord cannot increase your rent. Now, if you don't have a lease, and you're what we would call like maybe a month-to-month tenant, where your lease expired and you never renewed your lease agreement, so you're just kind of paying your rent every month, and then all of a sudden your landlord notifies you that your rent is going up, your landlord could do that as long as your landlord gave you the proper notice. So if you pay your rent once a month, and again, there's no lease, your lease has expired and you never renewed it in writing, then your landlord would only have to give you 30 days notice that your rent is going to increase.
And I said it wrong. Okay, the other thing, like he was saying, okay, just say the faucet broke, and you call and reported it. Someone came out to fix it, but they didn't really fix it. You call back to let them know that it's not fixed, but you get charged for them coming out to fix it. I thought that's what the deposit and rent was all about.
So the deposit is for when you move out.
Yeah, okay.
If there's damages or unpaid rent, then they can use the deposit to apply for that balances that you might have. That's what the deposit is for.
But it's not, he said it was tenant's responsibility, but it's not in the
I don't know
lease.
what is going on. Are y'all at the same apartment complex? Oh, okay. I'm just trying. It seems like a theme going on.
Really, I'm asking for somebody
It's
else
an issue.
because
Okay.
they couldn't come.
Okay. So
I know the situation.
So, and just going to what Attorney Farr said, the basic law under the South Carolina Residential Landlord Tenant Act, the landlord is responsible for essential services, which would definitely include plumbing. The only exceptions to that would be like what the judge described. If you putting diapers and stuff down the toilet, or you're doing something to actively break the plumbing, then arguably you would be responsible for that particular instance. So if you know somebody that is having a dispute with their landlord about a plumbing issue that was not caused by their fault at all, then they need to, Lynn, I'm sorry, they need to call Lynn's office,
Well, this person's been there 15 years.
I mean, at this point, regardless of how long they've been at the place, but, you know, at this point, they might need to get an attorney involved to communicate with the landlord, because as what you heard us say a couple of times today, a lot of landlords don't know what they're responsible for or what they should and should not be doing. So a lot of times they'll just throw stuff out there, and if the tenant doesn't understand what their rights are, then they'll just accept that. Do you see what I'm saying? So you would need, that person would need somebody to push back and say, no, this person isn't responsible for the plumbing, and then leave it up to them to say, oh no, they're responsible because, you know, they broke the pipes or, you know, whatever the case may be. But, I mean, I hate to sound, I don't know how else to say this, they need to get a lawyer involved. And the same thing from a brother in the back.
Okay, I tried to tell them that.
It's been, look, it's on the video. Play the video.
Okay, can the landlord daily ask for late rent? Like if you're late after the 5th, and every day after the 5th, it's $25?
It's a lease.
They can get late rent, but it has to be reasonable. It's, again, the term is unconscionable, so maybe 25% is way too much. And generally, if the landlord wants to do that, they need to put it in a written contract. If it's not a written contract, it's a month-to-month tenancy, then I would say that a reasonable amount would be okay, but reasonable would be for a court to determine if you felt like it wasn't right, you could bring an action in court to have the court decide that issue. And tenants and landlords can bring actions in court to have them decide issues dealing with their contract or with the month-to-month tenancies, any of those kinds of things. Courts are open for that to be decided by them and to help people so they make right decisions on these things.
Okay, now if I have problems, stuff just breaking, and every time my landlord comes and fixes it, he wants to raise my rent.
As everybody has said, the landlord is responsible for the plumbing, the running water, the electricity in your house, unless your children do some damage to it or you do some damage to it, and I've seen that happen, which is seldom the case though. Matter of fact, I'm dealing with a situation with my granddaughter who's having this same problem. She's had leaking water in her bathroom for 3 months. I sent them the 14-day notice, and I should have already brought action against them for it, but she doesn't want to leave the premises. So they claim they're going to fix it, but they say it's going to take months to get the stuff and all this kind of junk. But you have a right to bring the action to end the relationship if they don't work on it within 14 days, or at least don't start it within 14 days and finish it within a reasonable time.
And if your building is not up to code, how do you get that?
Oh, that's one that every week I enjoyed having when someone would raise that issue. Spartanburg has building code inspectors, Spartanburg County has code inspectors, and I would always delay a case when anyone raised that issue. Send them to those code inspectors to say, have them go and inspect this problem and bring them as a witness next week to court, and I want to hear from them. Because you've got amazing things sometimes, leaking roofs and all sorts of things. And that's why I tell landlords, read this code, understand your responsibilities. The tenants have responsibilities, the landlords have responsibilities, the tenants have rights, the landlords have rights. But many people don't understand either one, the rights or the responsibilities. Go to good lawyers, come to the master's court. We do everything, the court will do everything they can to assist you in the action, and the code inspectors can do the same type of thing.
I have a clarification question on her question, actually. If a landlord is continuously raising rent because they're having to fix essential services, isn't that considered retaliation?
They should never be able to raise rent to fix essential services unless, again, the tenant or some a visitor there deliberately or negligently caused the problem. Breaking out windows, tearing down screens, be shocked at how often that does happen.
Right.
And the landlord can make them pay for those things and can take that out of their security deposit and make them pay for those actions. But they can't make them pay for fixing the essential services that they did not. If the plumbing's so old and the pipes just break, or it's cold in the winter and they haven't wrapped those pipes or whatever, that's not the tenant's responsibility. That is the landlord's responsibility to keep running water, heat, and electricity going in that premises.
Okay. So my only question I had was, it's probably really stupid in comparison to everybody else's. One of the biggest problems I have had as a landlord personally is pets. So when you brought up the 14-day notice, what happens if they hide that pet on day 14 when I go to do that inspection, and then I see that pet there 2 days later? Do I gotta go do another 14-day notice?
It depends on what your contract says. If
Okay.
your contract says, if you're gonna have a pet, you gotta pay a pet deposit.
Yeah.
And they don't pay a pet deposit, then that is grounds for eviction.
Okay.
If the contract says no pets, and there are pets, that's grounds for eviction. And so, you know, it's up to the landlord whether they're going to accept. Very few premises, to my knowledge, accept pets inside the premises. Some do, I guess, and
We do.
but if you don't do it, and the person brings pet in, you got proof of it, that's grounds for eviction.
Okay.
So don't walk away, because I think the second part of your question is, just to make sure, is do you have to do another notice?
Yes.
I would say you don't have to.
Okay.
Judge, I don't know what you remember she said if she gave the notice and then the
Technically, the pet's not there on day 14, but then you turn around and you happen to be driving by and you're like, oh, hey, it's back.
I think you have grounds to evict. If that violated the lease, whatever it was, no pet, like what the judge explained, I don't think you have to do another notice after that.
No, I agree.
Yeah.
I think you have to.
Okay.
Evict.
What if your loved one is disabled and you just happen to be living with them to help assist in their care from time to time? Is it breaking the lease by staying there with your loved one to get care, provide
I
care?
think that depends on the terms of your lease agreement.
There may be some protections for the tenant, so the loved one that you're providing care for. Under the Americans with Disabilities Act, there are some protections where the, at least in a federally subsidized housing context, where the person can be added to the lease as a caretaker or as an authorized person, especially because a lot of times those properties have a 14-night requirement as far as when it becomes an issue. So if you're going to be there short-term, long-term, there may need to be some medical documentation from the treating physician or someone as to why it's necessary, but normally that can be addressed through a reasonable accommodations request under the Americans with Disabilities Act. It cannot be, a reasonable accommodation cannot be overly burdensome on the landlord. So there may be some things going on with the caregiver's background that's also prohibited under federally subsidized housing statutes. So that could be another issue. So it kind of does depend, but that is one thing that we've successfully helped tenants who are facing eviction for having an unauthorized caregiver in the home.
I gotta wait around because I got something everybody said. So the first one was the code, the building code, but for a house. If you get somebody to come out to see if it's up to code and it's not, but you take that paper to your landlord, do they have to fix all the things that's wrong with it? Can they put you out at that time?
Oh, absolutely not. They cannot put you out. No. Oh, no.
Okay. Second question about the essential. You said the air is not essential, but in the lease, if your landlord has it written down that, okay, I'm responsible with him as landlord, water, heat, and he also has the air, and it's in the lease, so he's responsible to come out and fix that, right?
Correct. Yeah,
It's
the
in the
essential
lease.
services is under the law, but anything that's in the contract, they can add additional things. For example, you can enter a contract in which the tenant is responsible for providing the heater, for example, as long as the two parties agree on that. The landlord's responsible for providing that normally, but you can reach an agreement that the tenant would do that, and that would reduce the amount of rent. There are things like that that occur, but those services still have to be provided, whether it's the tenant reducing the rent or the landlord providing it themselves.
Okay, the third one is like, I think this lady over there said about the rent going up. Okay, you sign a 1-year lease, that year's over, you go back to renew it for another year, they can make your rise.
Yes.
Now they can do it every year after.
Yeah, they can do it. Yeah, that's why you want to try to get a 3-year lease or a 5-year lease or something like that.
Okay, thank you.
But you understand now with the way housing costs is going up and how everybody's cost is going up, you're going to probably see more and more of that, unfortunately. Inflation is just hitting everything. So they do have the right to do that, yes.
Question, from a landlord's point, if someone calls, a tenant calls you with a maintenance issue, you send someone out there to fix it, but they won't let them in.
They have to let them in if they ask for it. They do have to let them in if they ask for it. Also, if something breaks and you know water's broken at your house and they're not there, you have a right to go in as long as you do it at a reasonable time just to protect your property. You have a right to do that as a landlord. So they don't have to be there. Normally they do. Normally you have to provide notice to them and everything. But if it's an emergency, then you can enter and fix the problem. If they keep refusing to let you in, you start an eviction action because it's violating the landlord tenant law for them to not allow the access.
One more question. The house that I live in, the rooms didn't have ceiling fans in them. So I bought ceiling fans and put in each room. The landlord said that when I move, the ceiling fan belongs to him, but I still have the light fixtures to go back up in case I move. So can he keep my ceiling fan?
Anything you would add to his property is his.
But can I put his light fixtures back up there and take my ceiling fans with me?
Once you do the changes, it belongs to the owner of the property.
Take the light fixtures with me.
If you buying a house, rent to own, you've been stayed in it, and then you buying it, rent to own, and then the owner dies and the children take over, and then they come up with a balloon loan, which didn't know nothing about a balloon loan.
Council already addressed to a large extent that when you say rent to own, lots of people don't quite understand that, and I've seen just unbelievable agreements of 30 years down the road and stuff like that.
Okay.
You'd have to take that to a lawyer and ask them to interpret it for you, because there's just no way we can know without what's in that contract. Legalese sometimes is very hard to understand for average people, so I got a feeling it's a very complicated issue.
If a husband and wife co-own a home, and one decides to evict the tenant and the other doesn't want to, is that legal?
Yes, one owner of the property can in fact evict. I would be very interested to see the tenant bring the other one to court, but either party that owns it has a right to evict. Now, I had a very interesting case when I first started. One night, this man came in and said, "My wife has taken my false teeth and won't give them back." So we issued what's called a claim and delivery action to repossess the false teeth from his wife. So those are the kind of interesting cases that we have. Most cases aren't all that interesting, but we do have a few interesting cases. And a few are in my book, as you might know.
If there's a, I don't know if this falls in this category, if there's a home on the land that can be moved a double wide on some land, and if the owner of the land wants that mobile home moved, is there a certain process you have to go through to do that?
As long as it's not permanently attached to the land, then they can evict the mobile home, yes.
And you just do the 30 days?
There's a process for that, though.
Yeah, it's more complicated than just average, you putting a person out, it's more complicated, but you can get it done.
Put my notes on that.
Hello, my name is Vivian. If you're renting, you kind of see mold that's coming on the walls. Do you go to your landlord?
First, you demand the landlord to fix that. That is a danger that you need to do it. And that's another problem my granddaughter's having in this premises.
So
The
if
water
he
causes the
doesn't,
mold. So you need to do it, serve them with a 14-day notice to correct that problem. If they don't fix it in 14 days, bring an action in court against them.
Okay, I want to pick it back up what she said. Now, my stove and refrigerator went out in my house. Now, he did fix it. It was like 30 days. So I went and brought my own, you know what I mean. I went and got my own refrigerator stove. So, now that's mine. So, shouldn't that come with me?
Yeah, now you can take, we're not talking about electronics or stuff like that. Anything attached to the house permanently. If you put an air conditioning unit outside, you can't take that. On the inside, the window air conditioning unit, yes, you can take that. Or the stove and refrigerator or anything like that, yes, that's yours.
I would suggest you keep your receipts and proof of purchase though.
Oh, I got it.
I have one for the panelists. If there is no written lease, how can a landlord give notice to terminate a tenancy?
It's a month-to-month tenancy if there's no written lease, so we give 30-day notice, written 30-day notice.
And the non-payment of rent provisions would still apply, so it would be a 5-day written notice for non-payment of rent, and then a 30-day notice. If there's no other provisions to violate, then there's not a 14-day for most things.
So what if he was given, less than 5 days, he can give a 2-day notice?
To pay rent that's past due?
Yes.
Oh, well, that's not.
Due on by the 5th, they give you a notice on the 2nd.
Wait a minute, when is rent due? Is it due on the 1st?
It's due by the 5th.
When you say by the 5th, do you mean late fees start on the 5th?
It's due, that's between the 1st and the 5th. But they give you a notice on the 2nd.
Before it's due. Give you notice before it's due, right?
Right, that's what I'm thinking. I'm thinking your rent is probably due on the 1st, but a lot of leases that I've seen at least, the late fees don't start until a couple of days. Right. But that's.
Is that just a reminder that you're getting? Reminder that your rent is due?
Okay, so the key is, let's just say, for the sake of this conversation, if your rent is due on the 1st, you have to, and you don't pay on the 1st, your landlord could give you a notice on the 2nd that says, hey, you didn't pay your rent on the 1st, so now you have 5 days to pay it. And if you don't pay within the 5 days, then they would file an eviction based on non-payment of rent.
Don't pay on the 1st, on the 2nd you get an eviction notice.
When you say eviction notice, are you saying from the landlord or from the court?
From the courts, they already got the paperwork in action on the 2nd.
You need to ask for your room to show cause of appear on that.
Yeah.
So you have a right to a court hearing. So if your landlord evicts you for whatever reason and you disagree with that, then that's when you would request the hearing and go in front of the judge and tell the judge why you shouldn't be evicted.
What I'm saying is that legal, they know the law, if they got 5 babies and they're doing it within Western properties.
No, so I think this is one of those situations where we can't directly answer it because we don't have all the details, but generally speaking, if your landlord just jumps to do an eviction and doesn't give you the notice, let's just talk about non-payment of rent. You have 5 days to pay it, otherwise your landlord will file the eviction. If your landlord leapfrogs that process and it's not in your lease agreement, like, because what Attorney Farr said earlier, if they put that language in your lease agreement, they don't have to give you a notice. So if it's not in your lease agreement, or you've been behind in your rent before and they gave you a notice, they don't have to give you a notice again. So those things have to be true. Like those things would, if those aren't at play, then that would not be a proper eviction, and an attorney could go to court with you, or you can go to the court hearing and say, Judge, he didn't give me the proper notice before filing this eviction, and the judge would dismiss that eviction.
One last question. If a landlord decides to sell a property, does he give that tenant, what is an adequate notice? I guess an adequate notice, is that 30 days, is that 60 days? That he notifies the tenant?
Well, I'm gonna say this. The first thing that popped in my head is it also depends on your lease term. So if you have a lease agreement, then that lease agreement has to be honored before, regardless of who buys the property. So I guess the question would be, are you on a month-to-month tenancy or not? Oh, it's
okay. Yeah, because then the landlord is saying, I want you to move out because I'm ready to move a relative in, but we're still under lease agreement.
No.
So
No.
is he violating my lease or am I, yeah, okay.
No, he can't. Whoever that is cannot do that. They can't. The whole point of a lease agreement is to lock you in. Well, so that means you can't change your mind and say, you know what, I don't want to live here no more. Because if you try to do that, you already know that the landlord will say, wait, you have a lease agreement with me. That's a breach of the agreement. So then they would have the right to ask for the monies that you would owe under that lease. So the same goes for the landlord. The landlord can't do it either. That will be a breach.
But I also want you to understand, he can sell the property, but whoever buys it has to honor that lease that you already
Keep it
had.
under the lease until you return.
Right.
Okay. Is that considered a cause or just the person that buys it, I don't want this tenant living here?
Person that buys it is bound by that lease if it existed before he purchased it.
The property is purchased subject to the lease is the terminology that's to be raised.
So keep your lease. Keep the lease. Keep a copy of it.
I know y'all ready to go, I promise, I won't get back up there no more. Okay, say if you went to pay your rent to the realtor, but the place is closed. And you didn't know they closed early because you wasn't notified, but they turn around and charge you late fees because you weren't there in time. But you have no way to leave it because everywhere you leave the rent at is locked. So what do you do?
Well, landlord's responsibility is to tell you where and when to pay the rent.
That's what I say.
As long as you do that, and they keep you informed on where to pay the rent. They can't charge you a late fee if you don't do it. But if they don't notify you of a change, then they cannot add a late fee to you. So what you would do is bring an action in court to deny them the right to do that. They would have to prove that they had given you adequate notice where to pay it and when to pay it. They can't do that, they can't charge you that late fee, and they can't end your relationship.
Okay, now, when the city inspector comes to your house to inspect it, and then they go to the landlord and send them a letter to let them know what needs to be done or whatever. Okay, I was told by a city inspector that if I did that, I was asking for trouble.
I believe I would call someone in government management in the city if that was what was told to you. The inspector's responsibility is to do what they're supposed to do, which is report any violations they find.
Okay, thank you.
Your property, so of course it's coming to our property and they're not gonna get it. So you just hold that envelope that's not been rendered or damaged or touched as proof. If it has money in it, a check, you just cancel it, you avoid it somehow on your records, and you just show proof that, is that how this, to make sure, you just can't keep that out there forever.
Right, absolutely.
So, is that how that works? Because I just want to make sure if someone provides you with an address that's not a real address that they gave you at the beginning.
Let me just add this, we're talking about my big mouth. We're talking about a security deposit refund. So one of the things that your tenant should do, or maybe you might need to tell them this, when they move out, they're supposed to give you a forwarding address.
Yes.
So they gave you a forwarding address that wasn't right. Oh, well then your duty is discharged.
Okay.
That's my, as long as they gave you that address on their way out, and you sent it there, I would do exactly what you just described. And then obviously, if you have a phone number, call them or email just to say, hey, I sent you your check and it got returned, what is your correct address? I would probably take that extra step. Like I said, I'm very, do your due diligence as landlords. So if you have an email address, phone number, text, just try to make some type of communication. But after that, if they're not responding when you're trying to give them a check, that's right. I'm just thinking like.
Send it by certified mail and keep a copy of the proof of where you sent it.
Question I have for the panel is, I'm a landlord and I have it in the lease agreement, and the tenant signs the lease agreement about me being able to make walk-through inspections. As long as I have that in there, can I make a walk-through inspection monthly, weekly, daily, or does it have to be specified in the lease agreement?
How often do you think you would need to do that?
Well, I feel like I need to do that at least monthly for the first 6 months, and then if they've gained my trust, then I would, not go as often.
I think that would be unconscionable. That would be beyond the average person's belief. Annually, maybe I would say would be okay, but I don't think I would set up anything shorter than that unless you have previous complaints of specific problems. Then you might want to renegotiate somehow or other, but I think maybe annual inspection is more than enough.
But if you have it, my question is if I have it in the lease agreement, and they sign the lease agreement, is it then therefore legal for me to go in monthly?
I want to represent them if you do that. You can't do that. That's an unconscionable, meaning shocking the conscience of the court. Everybody wants their privacy, but also the landlords have a right to a reasonable inspection. But monthly or weekly or monthly, it's just, nobody would want to open their house up to anyone that frequently. I think that would be extreme myself. I'd say an annual inspection if necessary. I don't see that in most leases at all. Annual, it's generally walk through at the beginning and walk through at the end generally, unless some problems have occurred and they bring those to court and the court will deal with them. But I wouldn't recommend those frequent inspections.
I think that would be reasonable than daily, monthly, I mean, somewhere in the middle.
And I mean, that's when you said that the maintenance of trust, I think too, it comes down to screening the tenant. Some things that you just, wanna make sure you do your due diligence and screen them so that you have a comfort level.
That's what I was thinking.
To make sure the screening process is consistent. That you do this, and this, and this, and this for everybody,
And you can't have a monthly inspection for insects or stuff like that, roach inspection or stuff like that, if it's set in there a specific time to do that. That would be fairly reasonable. But just inspect the whole house, I think you need much more time frame.
I get it. Like, I was just gonna say, I'm a landlord, so, that's your house. You wanna make sure that it's okay. I mean, there are ways. I like what she said, the air filter, switching out the air filter, if there's a maintenance need or something happens in the house, I'm looking around, just to make sure everything's okay. I know I was paying for a while for pest control at my property. So I would kind of ask the pest guy, hey, how did the house look? So, I mean, you can do that. I think there's ways to kind of address your concerns without being so overburdensome. So what we're saying is, not necessarily saying it's illegal, but if your tenant pushes back, you're a judge here, you probably would not be, the judge probably wouldn't side with you on that. So you might want to dial it back just a little bit.
I like the court.
Okay. I think that's fair.
Are there any more questions? We're gonna wrap it up. Well, thank you to our panelists for spending their time with us tonight, answering some questions, providing knowledgeable feedback for this workshop. We appreciate your time. Just in closing, just to put in a couple plugs, building codes, the county building codes department has shared with us, with our team, that if you have any questions and you're renting in the county or a landlord in the county, to please go by to their office at Building Codes. They're located at off of North Church Street. If you have any questions, please reach out to their department regarding inspections if you live in the county. I also would like to acknowledge our Spartanburg County Community Development Director, Kathy Rivers, who is here, but also Regenesis' team as well. Hi, Ms. Rivers. She's in the back. And I also wanted to recognize Regenesis' team. They have Marauder services, especially regarding around housing. If one of your team members wants to provide any additional information, there will be available at the end of our workshop. And if there aren't any other questions, please be on the lookout for for the evaluation forms. Those will be emailed out to you for all of you who registered through our Eventbrite. We would very much value your feedback today, so in hopes that we could possibly do this again. So thank you again for your time. Thank you for those who joined us online virtually, and hope you guys make it home safely tonight and that you have a great rest of your week. Thank you.
I miss you. Oh. So good.